Discharge of a contract refers to where the contract has ended and there are no future obligations arising from the contract. A contract may become discharged through performance where both parties have fully performed their contractual obligations. If one party does not fully perform the contract, this will amount to a breach of contract and the other party may have a claim for damages unless the contract has been frustrated. If the non-performance amounts to a repudiatory breach of condition, the other party will be released from their obligations. Where a contract is one where the price is payable on completion, then full completion is generally required in order to discharge the contract. This is often expressed in the terms of being a condition precedent. Completion triggers the requirement of payment. No completion, no payment. This general rule was established in Cutter v. Powell and is obviously capable of causing injustice. In Cutter v. Powell, 1795, the claimant's husband agreed by contract to act as a second mate on the ship the Governor Parry on a return voyage to Jamaica. The voyage was to take 8 weeks and he was to be paid on completion. 6 weeks into the voyage, the claimant's husband died. The claimant sought to claim a sum to represent the 6 weeks' work undertaken. Her claim failed. Payment was on condition that he worked the ship to Liverpool. Since he did not fulfill this condition, she was entitled to nothing. The harshness of this rule has been mitigated by the creation of various exceptions. 1. Divisible contracts. 2. Substantial performance. 3. Acceptance of partial performance. 4. Tender of performance. And 5. Performance prevented. The rule relating to discharge through full performance applies where there exists an entire contract. Where it is possible to divide a contract into separate parts, for example, if a sum is agreed to be payable per week or hour, then the courts can award a sum for the separate parts of the contract which have been completed. In Ritchie v. Atkinson, 1808, the claimant agreed to carry a cargo of a specified quantity of hemp and iron. The price agreed was £5 per ton for the hemp and 5 shillings per ton for the iron. The claimant only carried part of the agreed quantity. The defendant argued the contract had not been fully performed and therefore no payment was due. The court held that the contract could be divided into separate parts as the parties had agreed a price per ton. The claimant was thus entitled to payment for the amount carried and the defendant was entitled to damages for non-performance in relation to the amount not carried. A further exception exists where a court is satisfied that substantial performance is present. The court may then award the contractually agreed price and deduct sums to reflect the amount not performed. If, however, the performance is not considered to amount to substantial performance, the claimant is entitled to nothing. Difficulty arises as to what amounts to substantial performance. There is no precise limit set down, it is to be determined on the facts of individual cases. In Bolton v. Mahadeva, 1972, the claimant installed central heating in the defendant's home. The agreed contract price was £560. The defendant was not happy with the work and refused to pay. Defects in the work amounted to £174. The action by the claimant to enforce the payment failed, since the court held there was no substantial performance. Whereas in Hernig v. Isaacs, 1952, the claimant agreed to decorate and furnish the defendant's flat for £750. The claimant completed the work, but the defendant was unsatisfied with some of the furnishings and refused to pay. The cost of the defects in the furniture came to £56. The court held the claimant had substantially performed the contract, and was therefore entitled to the contractually agreed price, minus the cost of the defects. Where one party freely agrees to accept partial performance, then a sum is payable for the work completed. The main focus is on free acceptance. In Sumter v. Hedges, 1898, there was no free acceptance. The claimant agreed to build 2 houses and stables for the defendant. It was agreed that £565 would be payable on completion. The claimant commenced performance and then ran out of money. He was unable to complete. He had performed just over half of the contract. The defendant completed the work himself. The claimant sought to recover £333 representing the value of the work he had completed. He argued that the defendant had accepted partial performance by completing the work himself. This prevented the claimant from completing the contract. However, his claim failed. The court held that the defendant had no choice but to accept partial performance as he was left with a half-completed house on his land. where a party is willing to perform and tries to tender performance, but the other party does not accept the performance. The party seeking to tender performance is discharged from the contract, and the non-accepting party is liable in damages for non-acceptance. This was seen in Startup v. McDonald, 1843. The contract stated that 10 tons of oil were to be delivered to the defendant within the last 14 days of March. The claimant delivered the oil at 8:30 p.m. Saturday, March 31st. The defendant refused to accept the delivery because of the lateness of the hour. The court held the claimant had tendered performance within the agreed contractual period and was thus entitled to damages for non-acceptance. Where the promisee prevents completion of the performance, the promissor is entitled to payment for the work which has been completed. In Planche v. Colburn, the claimant agreed to write a book on costume and armor for the defendant as part of a series called The Juvenile Library. The agreed contract price was £100 to be payable on completion. The claimant commenced writing and had completed a great deal of it when the defendant cancelled the series. The defendant refused to pay the claimant despite his undertaking and the fact that the claimant was still willing to complete. The court held that the claimant was entitled to recover £50 because the defendant had prevented the performance. In summary, for a contract to be discharged by performance, generally full performance is required. This can cause injustice, so there are numerous exceptions to the general rule, including divisible contracts, where there has been substantial performance, if there has been acceptance of partial performance or tender of performance, and where performance prevented. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.